Welcome to today's episode. Today, we'll be covering workplace compliance when relationships develop at the office, Canadian pathways for spousal and common law sponsorship, and US immigration rules for marriage based cases, from eligibility to financial requirements. Let's get started. Today, we have Leona Wilson, president of the Armillary Business Group.
Hello, everyone.
We have David Nachman joining us all the way from New Jersey, managing partner in the NPZ Law Group.
Thanks so much, Mahek. It's not that far away. Nice to see everyone today.
And Gagan Mundra, barrister and lawyer at VisaServe Immigration Law.
Thank you, Mike, for having us on this show.
Amazing. So now let's begin, and I'll kick off by asking my first question to Leona. What are the HR compliance issues if two employees enter into a relationship?
It's a great question. It really depends on where the employees are working, what their position is within the organization in terms of the organizational chart, and also whether or not there are some policies that the company has in play. And so some of the compliance issues can come about if there's a conflict of interest. Let's say that somebody is starting to have a relationship with somebody who is a direct report to them. So the manager is in relationship with their employee. Right away, it's going to look like there's favoritism. Then there's also going to be the issue of confidentiality. And so is there information being shared with this employee that they shouldn't have? Because the communications and the information sharing at different levels of the organization and in different functional areas of the organization are quite different. And there can be quite an impact if information is being shared with somebody who maybe should not be having that in terms of the confidentiality and do they know what to do with it? The other issue that we run into as well is could there be a possibility of a sexual harassment at work? So in Ontario, our sexual harassment provisions that come under Occupational Health and Safety Act, there's one definition that is peer-to-peer, but there's another definition for manager to employee. And so we really want to know what's going on, not because we want to interfere with what is happening between people, but just so that the organization continues to work as it needs to without any kind of unnecessary drama. Everything is okay until it's not okay. And it's not good if the two of them are having a little personal dispute and everybody in the office knows everything and hears about it and sees it. So it's really around propriety and optics, in addition to those legal issues that are running in the background.
I think that was super insightful. My next question to Gagan would be, what are the legal issues that can arise from a workplace relationship?
That's a very good question. And again, I'm going to steal a lot of these points from Leona herself, where she so nicely pointed out about confidentiality, about any other misuse or misuse of the information that could potentially happen. Now, with any legal issues that comes up with partners at workplace, we are relying on provincial human rights code as well as employment law. And these protect the rights of employees at workplace when their partners are also working with the same employer. Now, the law abides by the core principle of safety, fair treatment, equal opportunities for all, regardless of any marital status or any relationship between the employees. And they also uphold justice and dignity in employment relationship. There is no place of discrimination, period. That's the end. Now, specifically, if I'm referring to Ontario Human Rights Code, they provide that questions based on marital status may be asked if the organization serves as a particular group of persons identified by their marital status, such as religious beliefs, social organization, educational organizations, etc. Now, for some employers, this marital status may also be reasonable and bona fide to ask for a particular job. Now, when we are talking about, again, the Human Rights Code and employment law, we are also putting an emphasis on anti-nepotism policies. Now, these policies can be what the Human Rights Code expressly states under Section 24(1), subsection D of the code. It permits the employers to enact anti-nepotism policies disallowing any employment relationship with a particular individual who has family or marital connection with an existing employee. This does not really help all the time. It just makes certain situations more complex because you cannot terminate an employee based on a family relationship. You cannot, it would amount to unfair prejudices and duress to the family member. So this has to be dealt very delicately, and as well as there may be a situation where confidentiality, as Leona mentioned, that would be affected. And this happens where we see it very often in managerial positions in financial departments. Those are the ones that directly, because of the relationship, would impact the confidentiality of the company. Having a very solid employee handbook would be helpful right up front, so that those relationships or any promotions, any wage increase, anything related that may impact by prejudice to any employee by the relationships standpoint would clearly be upfront dealt with, and that would help employers continue to hire employees having any marital relationship irrespective of it, and no prejudice might. These always have ugly heads if it goes forward in litigation. That's just my thought on it. Over to you, Mehak.
I think we ought to move on to the point where if the relationship survives legal and HR issues, what happens, David, and what are the different immigration pathways that a person can take who wants to get married to someone and there's a marriage case in the United States?
Such an interesting segue, Mehak, because I guess we've got to start with the fact that not all relationships are going to necessarily go in that direction. But I guess we'll look at the silver lining and be positive about it, that is a possibility for sure. I just want to go back on some of the things that my colleagues are saying. Gagan bringing up the handbook is an excellent point. I think that it's always important to make sure that the handbook circumscribes those particular issues. Actually, going back, I worked, and of course I'm showing my age, I worked on the Woolley versus Huffman-LaRoche case back in the day, which is that was the penultimate case in the United States dealing with handbooks, at least here in New Jersey. And in the handbook, that of course sets forth the policies for the organization, and could be no nepotism and no relationships in the office. One of the other points, I think, Leona, you had said is you mentioned the various types of relationships within an organization. You didn't mention manager to manager, which I guess is also one that could potentially occur. That's a possibility, and I wonder whether that gets treated differently. I leave that as an open question, more rhetorical than anything else. But before we go on, I just want to, Mehak, answer your question, and that is, what are the various ways in which you can have relationships that potentially culminate in marriage in the United States? Well, and it's a little different than it is in Canada. I think that Gagan and I have had some interesting academic discussions about the various types of relationships, because you do have the common law partnership in Canada. We don't have that in the United States. So in order to have a bona fide marital relationship, of course, there has to be a legal marriage. And one of the ways in which it can be done is if the individual enters the United States as a visitor, or let's say they come into the United States in valid status and they marry a U.S. citizen or a green card holder, they can seek to obtain status in the United States. A little more challenging if they're a green card holder, because it takes a little longer, because they come into these family-based preference categories, which unfortunately are backlogged a little bit. But let's assume the individual, the foreign national, is from Canada, coming into the United States. They come in as a visitor, they file in the United States, and they can adjust their status to that of a green card holder in the United States. It's a very quick, I always say to my clients, quick, easy, it's one of the least expensive ways to get the green card in the United States. But there's another methodology that can be used if you decide maybe you're not ready to get married and the relationship is not that far along, is a fiancé visa. And the fiancé visa is a little different. You can apply for a U.S. citizen can apply for, not a green card holder, but a U.S. citizen can apply for their fiancé at a U.S. consulate office abroad. And so in this case, you would submit the case for approval to the USCIS, and then have the approval notice cabled abroad, and then the individual picks up what's called a K-1, and they enter into the United States as a fiancé. They must get married within 90 days. So that's one of the parameters. So there are various ways. Again, we're looking at the silver lining, and this is the happy result that the relationship that is developed in the office does go in that direction. And obviously, if it doesn't go in that direction, then of course, all of the pitfalls and I guess the slippery slopes that Leona had pointed out could potentially result. So back to you, Mehek.
That's quite interesting. I think the K visa can help a lot of people navigate before they make a final decision in their relationship. Moving on to Leona for the next question. Should there be a policy against workplace relationships?
Thank you. Yes, there should be a policy. That would be ideal. And just to come back to David's point, manager to manager would be considered peer to peer. So we would have those same issues, but of course we would be paying attention to the confidentiality, the access to information as well. So it does get captured in there. It's not so common to see manager to manager, although it certainly does happen. Usually a manager is going to be in a subordinate role to maybe their partner. So you could have two people that are on the management team, but one is in a higher position than the other. So that will muddy the mix. It's contextual. So thank you for bringing that up. But coming back to the policy piece, as Gagan had mentioned, we can determine whether or not there's going to be an anti-nepotism policy that's going to apply in the organization. In some companies, they're just family businesses from the get-go. They don't care about that sort of thing. In those types of organizations, we're more concerned about the individual not being in relationship with their direct report, that there should be a little bit of a buffer or a layer in between just for the conflict of interest and also for a little bit more of the confidentiality. So at least it looks good on paper. People are going to say and do as they do on their own time. But where we have an anti-nepotism policy in place, it's important that the policy outlines when it needs to be disclosed and also outlines that the organization is going to work with the couple to determine who it is that's going to leave. And I've certainly had experience with this, and we do have to treat it as a regular kind of termination. One organization that I was at, what we decided to do is we provided the one individual 6 months to go and find another place of employment. So they could continue to work while they were looking. They were able to find something in between. If they wouldn't have found something at that point, that would have been considered working notice from our perspective. And there still would have been a bit of a payout that's there just to maintain the goodwill with the partner who is still remaining. So the policy becomes important. What I think is always difficult is when we make up the rules after the fact because we're not happy with something, and then it can feel very arbitrary for employees. And it can really result in a lot of pushback. That information right up front just makes it easier for everybody, but it's important to know what we can and what we can't do and what we can and cannot expect to happen as our mechanism. So I'll turn that back to you, Meg.
Yes, I think that's quite interesting. We need to understand that procedure comes as precaution as well. And my next question to Gagan, what is a common law relationship? And is it the same as a conjugal and spousal relationship?
That's very interesting, especially when we hear that we have K visas in the US, which gives some scope outside married relationship. In Canada, we are, I think, way ahead. And we also acknowledge a relationship between, we have common law partners, we have conjugal partners, as well as a conventional, traditional marriage. Now, most importantly, even before we go into the definition, in Canada, we define marriage or relationship between two people. It's not about two, it could be same sex, it could be different. It's no more between man and a woman. That's bygones long time back. Now, with Now, leaning towards the definition according to the Immigration and Refugee Protection Regulations, married means where it's a marriage between two people, where there had been a ceremony that legally binds them to each other. It's important that the marriage is recognized not just in their home country, but it must be recognized in Canada as well. So marriage by fax, by Zoom, by any remote means, by proxy, that's not acceptable means, whether it could be acceptable in their home country. So it becomes very important that if you say that you were married by your culture and your culture allows you to marry in certain ways, but Canada does not accept that kind of marriage, it becomes a little bit of a dispute out there. And we just have to find out how we can realistically prove, based on any cultural support, any documentation which is based on research by scientists, by scholars, etc. So that would be a way around it. We also have common law partners. Common law partners are same as married couples with all the benefits, rights, and responsibilities. The only difference, they are not legally married. They've been cohabiting together for at least 12 months or more. Conjugal relationships are also recognized in Canada, and these are foreign nationals residing outside Canada who are in a conjugal relationship with a sponsor for at least 1 year. Now, typical examples are foreign partners cannot obtain divorce in their home country, or same-sex marriage is not recognized. Such partners may not get visas to enter Canada, so they are into a relationship while they are outside Canada with their Canadian spouse, who could be a Canadian citizen or a permanent resident. So just to accommodate that kind of a unique situation, this conjugal partner relationship is also being recognized, but it comes with loads of information and documents to support the genuineness and bona fide of the relationships. It becomes tricky because there are too many caveats to it, and you cannot just get up and say that I've been knowing them for about months and years over the phone. There has to be much stronger relationship beyond that knowing part. Over to you, Mehak.
That's quite interesting, that the nuance between conjugal, spousal relationship, and obviously common law. The details are so minute. Moving on to my next question to David. Is it true that unauthorized work and unauthorized stay are not a factor in marriage cases in the United States? Could you please explain a bit more about that?
Yeah, I'd be happy to, Mehak. I think it's really interesting listening, Gagan, to the way the Canadian laws are designed, because it seems like they're so much more progressive than it is in the United States, because we're locked into, it has to be a bona fide marital relationship that exists. And it's interesting, if you trace back, I guess, historically, the way the law was written and what the thought process was that goes into it. We always talk about the difference between the Canadian law and the US law. The US law is antiquated to a certain degree. The Canadian laws are much younger and allow for a tremendous amount of flexibility. I think the US laws are grounded in a puritanical view of the way things have to be. And it's almost like they just haven't caught up with reality. It's interesting. A marriage case is based on, as you rightfully point out, on the bona fides and proving the bona fides of the marital relationship, which is done in a variety of different ways. So you prove through cohabitation, through joint financial responsibility, through messages that are sent by relatives or friends attesting to the fact that it is in fact a bona fide marital relationship and not being done solely as an accommodation for the green card. So looking at it historically is just so interesting to me. And now getting to the answer to your question, which I sidestepped a little bit there, but that's why this type of discourse is really so interesting, is that, yeah, so in the United States, when you marry a US citizen, and it's not the case when you marry a green card holder, but when you marry a US citizen, that case, if you file it, is a safe harbor against unauthorized stay, which people have to sometimes be concerned about if they're out of status. As long as they enter the United States with inspection, they can get a safe harbor against unauthorized stay. So even if they overstayed their visa, and one of the things that we get concerned about is if an individual overstays by 180 days, then there's a potential prejudice because the 3-year bar, or if they overstay by a year, the 10-year bar attaches. So this is a safe harbor against those bars, a safe harbor against unauthorized stay. If there's unauthorized employment, under one of the adjustment of status provisions, we call it 245C, then if you have unauthorized employment, that could be a bar to your being able to get a green card. However, if you're marrying a U.S. citizen, you're not adjusting under 245C, you're adjusting under 245A. And I'm sorry to throw around those provisions like in the law, but it's important to know that there's a distinction between the two provisions that you're going to be adjusting under 245A, marriage to an immediate relative, or what we refer to as an immediate relative petition, which could take other forms. Like, for example, if an individual is applying for their parent, that could be an immediate relative case also. So when you do those 245A cases, then that allows you to not have a problem with any unauthorized work that you may have engaged in. So again, it's a safe harbor against unauthorized stay, and it's a safe harbor against unauthorized employment. So definitely the value of an immediate relative case. So with that, I'll go back to you.
But I'll just quickly add over here, David, that in Canada also we had a fiancé visa, and that was sometime in 1970s that was initially started with the practice. Then in 2002 changed, and they said, no, we see a lot of marriage fraud, and fiancé visa is not the way that we are going forward. They kept common law partner, conjugal partner, those visas, they left it intact. But with fiancé visa, they found a lot of fraud, and that's the possible reason that they brought it all to a big stop. I'm guessing that in US also now it's becoming tougher. It's not as simple as it sounds. You have to come and marry the same person and not end up marrying somebody else. And that timelines of 90 days, that's important as
So that's a great point, Gagan. And actually, I was going to start with that. You got me going on the historical view, but I was going to start out by saying the thing with the K-1, the fiancé visa in the US, when I'm advising clients, is I usually am like, well, how far along are you in your relationship? Because I would rather see you go ahead and get married, because I call that you're putting your money where your mouth is. Whereas if it's a fiancé visa, it's less strength, because the government is less likely to grant that, because they know that maybe the individual is going to enter the United States and may decide, okay, maybe I'm going to marry someone else. So it's a really good point that you make up. There is a case called Matter of Cesse, which does give individuals the ability to marry another US citizen, but there are very strict parameters around doing that outside of that 90-day period. So it gets a little dicey, but it is something that can be done depending upon what documents. It's actually has to do with the I-864 affidavit of support, if it has or has not been approved and for the case. But all great points. So thanks so much for taking us back there. Yeah, it's good.
That is so interesting that the more they put laws in, the more people find ways to navigate through them. But moving on to the next question. So far, we've been assuming that all of these relationships at the workplace or outside of them are disclosed. Leona, what happens if an employee or two employees do not disclose a workplace relationship?
Thank you. It happens, and we do see it in the media from time to time, and generally it doesn't go so well. The key elements here is, what is the policy? So the policy is one thing, but then if we have individuals who have a fiduciary responsibility, that is almost a higher standard that's there. And whether there's a policy there or not, people at that level are held to a higher standard. It just is, and it's expected that they would know what is expected of them. Nevertheless, sometimes individuals are feeling that it's a personal thing, nobody will ever find out, it's okay, whatever. And when these relationships come out, it automatically calls into question trust. What is the level of trust that we have between one another when people are engaging in such activity and not disclosing? And so there's that credibility issue that's there as well. It can also create some significant issues for the organization, depending on the levels that these individuals are in. It really can be a reputational risk for an organization, and it can result in termination. We've seen that in the US with the famous kiss at the Coldplay concert. We've seen it here in Canada with the allegation of the relationship between the CFO of RBC and somebody who she promoted a few levels up, who was working for her as well. There are many instances of this. Generally, If there is something like this, it should be disclosed. If we're talking about two people who are working in the warehouse together and it just evolved and they just didn't bother to flag it out to somebody, I don't think we have the same level of consideration. Just so long as there isn't a lot of drama that's happening in the office and everybody's being brought into the minutia of the day-to-day details, we really look at that a little bit differently. But the more senior the individuals are, I think the higher the standards are, and the more we get concerned that we're finding these things out by accident or by seeing them on TV or whatever it is. So with that, I'll turn that back to Meg.
I'll quickly add to that point, Leona. You've made such a fantastic point about the fiduciary relationship and how they are responsible. We see it sometimes in courts as well, where the counsel has had any relationship, not just with the opposing counsel, but maybe with the client that they are representing. And then that's it. That's the end of that part of the litigation. It just starts all over again. So it just becomes so important to be clear right up front, show the relation, it's okay. It just saves everyone from tremendous amount of issues that could be in litigation or any other form that we won't even imagine.
So it's a great point, Leona. And actually, what we did is we just recently told our legal counsel, who are revising our handbooks, to just write in a sentence that no staff are allowed to attend Coldplay concerts.
Well, here's hoping that prevents a lot of missteps, Dave. My next question to Gagan is, how does a foreign national prove that their marriage is authentic and not a fraud?
That's a fantastic question, and IRCC is always looking for, is the marriage genuine or fraud, and how are they deciding? Guess what? There are no laws that clearly points out, oh, based on these factors, the officer finds the marriage is not genuine. It's only based on balance of probabilities that the relationship is genuine or not. That's when the officer decides on it. We have a regulation under Section 4.1 under Immigration and IRPR that provides that a foreign national shall not be considered a spouse, common law partner, or a conjugal partner if the person entered into the relationship to obtain any status in Canada or is not genuine. So this criteria is already in our regulations, but then there are no set of criteria which can determine whether the relationship is genuine or not. It cannot be judged under stereotype lens when it comes to differences in their age, culture, occupations, etc. The officer cannot say that, I didn't see that how they're different religion, how they are from different religion and culture, and how are they even going to live together. We've had these cases in the court, and the courts have always refused this kind of position from the officer and has always found them very stereotyped. Now, the federal court we have is in Koff versus Canada, which is in from 2014. It indicates that it is exclusively up to the visa officer to determine whether the relative weight to grant each factors based on facts, inherent logic of applicant's story according to a particular clues, references made by the applicant themselves, meaning the encyclopedia of references, a dictionary of terms, picture gallery of the applicant's file, in addition to an assessment to determine whether the facts on file taken together create a harmony or discord. That's so important when it becomes on the totality of circumstances. Does your story fall apart? Or does that everything add together for the officer to think that even though your partner is outside Canada, you did had that genuine relationship by your Facebook status, just as simple as that, or your chats, have the family member met them? How is the relationship going on when it's all over the phones or emails or texts, etc. So everything adds up to prove the genuineness of the marriage. There is no one formula. If you're true, they'll see you. We come across such unique situations that even any law books would not even cover that. We have this question that came up on our list, sir, where they're saying that, okay, what do I do if I have a common law partner up here in Canada and I have a spouse overseas? How do I sponsor my spouse overseas when I also have a common law? I don't know. This is such a gray area, and it requires so much of digging, not just to their culture, to their religion, but what what's happening with the relation that's outside, which by no means this individual wants to leave. So yes, it's a great area. It's a complex area. Just as much you think that it's simple husband and wife. No, it's not two partners. It's beyond. Over to you back.
No problem. That was again extremely insightful. David, my final question to you. In the United States, there's a requirement for an affidavit of support that a petitioner needs to provide at the time of application. What if the petitioner does not make enough money?
Right. So, and this is an area that's being scrutinized a lot more. And actually, it really came under the microscope during Trump 1.0, and now is still under the microscope under Trump 2.0. I referenced earlier in a matter of Sese the importance of having an I-864 filed. And the I-864 is a document, we call it an affidavit of support. It's this affidavit of support, the I-864, was implemented in the law in 1996, also under when there was a Republican administration. And it was actually a Democratic administration seeking re-election. So they handed over the immigration laws to the Republicans who actually put this in. And what the I-864 does is it sets forth a level of support that's required, which is reported by the U.S. Department of Health and Human Services on an annual basis. And depending upon the household size, will depend upon the amount of money that is required for an individual to be demonstrating on their tax returns in order to file the affidavit of support for an individual that they may be sponsoring. If you do not meet that requirement, if you are unable to meet, you still have to file the I-864. However, what the government's going to do is they're going to outright ignore the first I-864 that's been submitted if it doesn't meet the criteria. And then what they're going to do is they're going to look for either what's called a co-sponsor. It's another individual who can come in who either has a green card or is a U.S. citizen who can sponsor. And that means does have enough to meet the parameters of the HHS guidelines, depending upon the size of the household. Or what they do is they have an asset algorithm that you can follow. The problem with the asset algorithm, unfortunately, is that they base it on liquidation value. So it gets very confusing for the officers who are adjudicating these cases. And unfortunately, in my multiple years of practice, and I'm not bragging about that, by the way, in my multiple years of practice, I've never actually had an asset case that's been approved. So they're usually looking for that affidavit of support from someone else who, again, does meet those guidelines. So the I-864 becomes part of the package that's submitted on behalf of the individual, and it's handled either at the U.S. consulate as part of the upload to the NVC, the National Visa Center database, as part of the package that gets sent to the U.S. consulate if the individual will be picking up their visa there, or if they're adjusting status in the United States, it's part of the inquiry that the officer will make when they interview the individual to determine also whether or not they're in a bona fide marital relationship.
But then I'm curious to know, David, why would there be a requirement for this kind of a sponsorship? In Canada, we don't need. If it's a spousal application, we don't need. There are a few caveats, of course, but there is no sponsorship or the funding requirements as such from the sponsor when they are having their partner come over. So do you know why would that?
Yes, so it's a great question, Gagan. It has to do with what's called there's what's called inadmissibility, and there are a variety of different rules for when a person is or is not admissible. For example, if we have individuals who have certain crimes, then they are deemed to be inadmissible. And one of the bases for inadmissibility has to do with whether or not an individual is going to become a public charge. If they're going to become a public charge, then you can't get the case approved. So what the I-864 did was it was designed, it's interesting because again, I love the history of the law. It's interesting. If you go back before 1996, there was a different affidavit of support that was used. It was called an I-134, but it didn't have any teeth. It was a document that you would put forth to explain the individual, how much they make, and allegedly they would not become a public charge. And then all of a sudden what happened in 1996, they said, well, we need an affidavit of support that has some teeth. to it. And so the affidavit of support that is submitted by the petitioner for the beneficiary being the foreign national, the petitioner being the US citizen, what they're doing is they're actually agreeing to support the individual even if they get divorced. So and it's interesting that I-864 is a contract and it remains in place for 10 calendar quarters. It's actually 40 calendar quarters or 10 years until the individual passes away or they leave the United States permanently. So even if you get divorced, there's still a potential cause of action under that I-864 by one spouse against the other, or former spouse, I should say. So it's really interesting. Again, historically, what happened was they were focused on this issue of inadmissibility, and this is the way they decided to deal with it.
That's a great point. Thank you for clarifying.
Thank you for asking. Back to you, Mehak.
All right, and that was our final question. So I would invite anybody here to submit their closing remarks, or is there anything that you guys would like to add and say?
Well, I have learned an awful lot about the complications with immigration. As an HR person, I'm dealing with people who are here, who are able to work, and there's so much more that's to it. It was very educational for me, and hopefully will be for our viewers as well.
I'll just quickly add and chime in that marriage just as much things so easy. Just be careful. There's a lot of marriage frauds and misrepresentation that might end up, and that would actually stop you from coming to Canada. So be very sure which relationship and the relationship is genuine and bona fide.
And I just want to comment to my colleagues that this was not an easy subject to discuss within the realm of human resources and employment. And we covered into a family-based area and brought it all together really nicely. So I just want to say this is a great subject matter that you guys chose, and I was pleased to be a part of it. So thank you for inviting me.
Well, thank you to all three of you for being part of this, because I know anybody who's watching this who may be looking at marrying a foreign national, they may be based out of US or Canada, will be really interested to know all of these facts. And I think we may have helped them a lot. So for all those watching, please subscribe to our channel and click the bell icon so you're updated of any notification or whenever we post. And stay tuned for the next episode. Thank you so much.
Thank you.
So that would be a way around it. We also have common law partners. Common law partners are same as married couples with all the benefits, rights, and responsibilities. The only difference, they are not legally married. They've been cohabiting together for at least 12 months or more.